Anna Hickey that we have started streaming. Have we started streaming? I think we have. All right. We are live. It is Thursday, December 21st, 4:00 p.m. I am here in the virtual jungle studio, or in my case, in the hammock studio, with Anthony Michael Kreis and Anab Bower. Anab Bower is, of course, in the encyclopedia room of her palatial mansion. And Anthony, where are you joining us from?
I'm in my apartment in Atlanta for a few more days before I head up to New Jersey to visit family. So ground zero, I suppose, down in Fulton County.
Excellent. So yeah, I'm feeling very outnumbered today because usually we outnumber the DC people, outnumber the Atlanta people or the Fulton, the Georgia people by at least 2 or 3 to 1. But today we've got it reversed. They've got me outnumbered. And we've got a lot of Georgia stuff to talk about. So let's get rid of, first of all the non-Georgia stuff first. Let me introduce our special guest, which I have neglected to. I'm so used to people knowing who Anthony is, because back from the In Lieu of Fun days when Kate Klonick and I used to do this live show, he used to be on it pretty frequently. And so I'm used to just being able to say, Anthony's here. But no, you can't do that with the Lawfare audience because they don't necessarily know you yet. Anthony is a law professor at, it's Georgia State, right? Not University of Georgia. And he's a constitutional historian. He is been following matters in Fulton County with particular care on that site that I don't get to go to anymore. There's been a lot of Anthony live tweeting things and being a serious lawfare person. And of course, Anab Bower needs no introduction here. So we're going to talk about Mark Meadows at the 11th Circuit. We're going to talk about all kinds of fun Georgia stuff. But I want to start at the U.S. Supreme Court, where we had a flurry of briefing over the last few days on the question of whether the court should grant cert before judgment in the immunity matter that is on appeal from Judge Chutkan. Anna, bring us up to speed about what has happened.
Right. So if people recall, Judge Chutkan rejected Trump's arguments that he is shielded from prosecution under a kind of novel theory of presidential immunity, trying to extend the immunity that has been recognized in the civil context to a criminal context. And Trump then appealed to the DC Circuit Court of Appeals. And Jack Smith, in an effort to kind of preserve this March trial date that has been set by Judge Chutkan in the January 6th federal case, kind of, decided to step in and go ahead and ask the Supreme Court to hear the matter, before even the DC Circuit Court of Appeals decides it. So the Supreme Court is now weighing whether or not to grant cert or to hear the case. They've not yet decided, and there was an expedited briefing schedule that was set. So we had Trump's team who submitted briefs saying, no, the Supreme Court shouldn't hear this case. It should go in the regular kind of course of going to the intermediate appellate court, then going to the Supreme Court. They claimed that Jack Smith does not have standing to, go ahead and bring the case to the Supreme Court because they are not the basically because they were not the losing party in terms of who is appealing. And then we got a response today from Jack Smith's team who said, in effect, the public has an interest in a speedy trial here. These charges are very serious. This is a novel question of law. And also you're wrong about this, standing issue because, we're not appealing. We are just seeking review from the Supreme Court as has been done in other cases of great importance. They cite, the Youngstown Steel case and United States versus Nixon. So these other cases where the prevailing party still went ahead and asked for cert before judgment and was able to do so without any, questions about whether they had so-called standing to do so. So that's kind of a summary of what we got this week, Ben.
Yeah, so there's only one interesting legal issue here, and I don't think it's very interesting, but Anthony, correct me if I'm wrong. I think Trump is just wrong on the standing question, right? So the normal rule is that you can't appeal something that you won. The government didn't appeal this, Trump did, and all the government is asking for is for the appeal to be at the Supreme Court, not at the DC Circuit in the first instance, right? There's no standing barrier to that, right?
Right. I mean, fundamentally, I don't think you could put it any better than you just did, right? The government is not appealing a favorable ruling. They're just simply asking for the process to be expedited on the appeal that Donald Trump has decided to lodge. Although I do think there is something different about the kind of dynamics of this case, right, than some of the other ones like United States versus Nixon or the Youngstown, sheet and tube case, which is we're dealing with a criminal prosecution here. Of course, it's the highest interest for the public, I think, to get this done sooner rather than later and to have this all out in open court and whatnot. But I do think that does make this a little bit different. But ultimately, I think these questions that we've seen from like these collection of state attorneys general claiming that there's just something very partisan and unusual about this and it's untoward and the court shouldn't be doing it's just inconsistent with history. But of course, the ironic part, right, is that it's inconsistent with what much of Trump's DOJ did, often seeking cert before judgment in litigation that the Trump DOJ was pursuing and involved in. So there's a bit of irony there too.
Yeah. So how do you assess? The court set a really quick briefing schedule for this. They seem to take the special counsel's request for a highly expeditious consideration, at least of the cert before judgment motion, pretty seriously. What do you expect to see from the Supreme Court, not on the merits, but on the, do you expect them quickly to grant cert before judgment, quickly to reject it, or slowly to do one of those two things? What would surprise you and what would not surprise you here?
Well, I'm not really I'm really hesitant to say what would surprise me or would not surprise me, in large part because there is so much going on here. And in this case, I think we need to think about this in the broader universe of cases that are before the court now, right? Which is the court will have to deal with, right, one of these main statutory interpretation issues in all the January 6th prosecutions about, right, what it means to corruptly interrupt, right, a government government function. At the same time, we have the Mark Meadows appeal probably coming from the 11th Circuit. There's the immunity question. There's the Colorado Supreme Court disqualification issue, which will probably be appealed very quickly to the Supreme Court. And I, when we've got four really major questions that speak to the heart of our democracy and the meaning of democracy and the rule of law and our constitutional order all coming to the court at the same time, I often think about a very famous quote from a Supreme Court justice in the mid-1950s who apparently or allegedly responded to, why why won't the court, in the immediate aftermath of Brown versus Board of Education and desegregating public schools, take up anti-miscegenation statutes? And he responded, well, one bombshell at a time is enough. Right, the court is a political institution, it's a political organ, it's dealing in with highly salient issues in a political environment, and I think they're going to be thinking about how to handle all these cases potentially at once, kind of in, or at least they'll be considering how to manage all of these things. So maybe it's maybe they'll see it to their advantage to take it up quickly and at least get rid of one of these major issues out from under them in short order, and maybe they'll slow walk it and maybe I was always of the belief that they would just let the DC Circuit rule against Trump and then just leave it at that, and then just deny cert and walk away, and that was the easiest way to avoid this. But Jack Smith is certainly not is not letting them really avoid it now.
What are you expecting, Anna? What would surprise you and not surprise you?
I mean, I certainly think that the court is going to. I wouldn't be surprised if the court takes it before judgment, and decides the question. I also would be very unsurprised if the court doesn't, or excuse me, I would be very surprised if the court doesn't, to some extent, agree with Judge Chutkan and ultimately, or rather that it may be that the court decides, there is some universe in which there is absolute immunity or some type of immunity from criminal prosecution for a former president who committed allegedly committed criminal acts in the scope of their office. But I also think that they will ultimately decide that kind of doesn't matter here, and that in any case, these are not the facts in which they would decide that immunity doctrine applies. I think that was total word salad what I just said, but hopefully it made sense. But I think that is ultimately kind of maybe what the outcome is here. I also think that, and we'll get to this, but it is telling to me that the 11th Circuit opinion that it just came out in the context of the Mark Meadows removal litigation, written by Chief Judge Pryor, a very conservative judge of the 11th Circuit, dealt with this kind of similar question of, obviously not in the absolute immunity context, but still had to decide whether some of these actions were within the scope of office, and they ultimately decided that it was not. And so I think that is maybe a signal of what the Supreme Court could decide with respect to Trump, and whether, if there is a doctrine of immunity that applies, the question of whether he was acting within the outer perimeter of the scope of his office as president. So, and again, I think we'll get to that conversation in a minute.
You're cheating
sorry.
by going into the 11th Circuit stuff before I'm ready. So before we go on, we have not one, but two requests in the chat, Anna, for an introduction to the dog.
Right.
And so I think we got to pause for a minute so you can introduce the dog.
Right. So this is Bullet. He was my grandfather's dog, who unfortunately passed away, and we took him in. He is not named after the deadly ammunition for deadly weapons, but he is named Bullet because he's very fast, or he was in his prime. And he's a little schnauzer who would run away all the time, and my grandfather would have to run down the streets of South Georgia after this dog to try to get him to come back. But now he's an old guy, so he doesn't run so fast anymore, and we don't have to worry about that anymore.
But you all will recall how last week or the week before there was dog barking issues. And so this week we decided that Bullet should remain on the lap, as that would be less prone to a barking at passersby situation. All right, I'm gonna give you the answer on the cert before judgment. It will be granted tomorrow. That's the answer. The Supreme Court, I'm not sure what the vote on the merits is going to be, but everybody's going to agree to do this quickly, and we're going to have cert before judgment before before the day is closed tomorrow. That's my prediction, and you can hold me to it. All right, let's talk about that 11th Circuit ruling, because in the spirit of proving Ben wrong about everything, which you should keep in mind when assessing that that cert before judgment prediction, the 11th Circuit has upheld the lower court's denial of removal to Mark Meadows. This was a case that one Anab Bower, one Ben Wittes, and one Alan Rosenstein thought was going to be pretty hard and might actually warrant removal. The district court said, you're full of shit on this, Wittes. And the 11th Circuit said, you're even more full of shit than you knew, because this statute does not apply to former officials. So none of the analysis that you did has any relevance at all. So Anthony, get us started on this. This is a pretty substantial ruling. What did the court hold, and why should we care?
Yeah, so I think first of all, it's important to note who was on this panel. So it was Chief Judge William Pryor, who's one of the most conservative judges on the court, and two of the more liberal members, Judge Rosenbaum, and probably the most liberal, I think, member of the court, the newest member, Judge Nancy Abudu. And so the question that they had before them was whether or not the text of the removal statute includes former officers of the United States, and not just protects current incumbent federal officers, federal workers, federal contractors when they're sued or when they are criminally prosecuted and seek removal. I think that most people thought that that it just naturally makes sense that if somebody's conduct is being targeted in a suit of some kind that is related to their federal employment, even though that they're former federal employees or former federal officers, that the statute would cover that, because the statute was really meant to protect federal federal personnel very broadly. But of course, the statute does not expressly say current or former. And so the 11th Circuit was very much interested in this question about whether the lack of an express inclusion in the statutory text of former federal officers being entitled to removal meant that that's in fact how it should that the statute should operate, right? That former officials should not be able to remove criminal cases into federal court at all. And I think the court was very straightforward about this point. They, Judge Pryor in oral arguments, I think, was pretty transparent that he just thought that the text said what the text said, and that the lack of an express requirement or an express inclusiveness of former officials just meant that they're out. I think that the liberal judges, and this came out in a concurring opinion, we're a little bit more concerned about the nature of harassment that might come up, or the amount of harassment that might come about if former federal officials could be prosecuted and brought into state court and tried in state court for crimes related to their federal service, primarily if that prosecution was just motivated by a policy difference. And so they definitely expressed some issues and some hesitancy there, and thought that Congress should amend it. But I think ultimately the other important part of this is that despite the fact that the 11th Circuit said former officials cannot seek removal of their criminal cases into federal court, that even if they could, that the lower court's ruling here was correct, that Mark Meadows did not engage in activities within his purview as White House Chief of Staff when he was involved or allegedly involved in meddling here in Georgia, that the White House Chief of Staff has no obligation, no duty in overseeing elections and election results, that the former Chief of Staff, as Chief of Staff, had no right or under federal law, under the Hatch Act, to engage in partisan electioneering, which is much of what he was doing. And there's no right or there's no privilege of a federal employee in the White House, and particularly the White House Chief of Staff, to engage in a conspiracy to overturn an election. And so even if the statute applied to Mark Meadows, he would not be able to seek refuge under it. And I think part of what's going on there is that the court, in many respects, is insulating itself potentially from Supreme Court review to decide, particularly, right, whether the former officials get covered. Because I think that would be a question very ripe for cert. Although I think this case is probably not a good vehicle for deciding that ultimately. And the court's explanation of how it would not apply to Mark Meadows, even if their statutory interpretation ruling was wrong, I think is kind of a way to deter the court from seeing this as a good vehicle for that question.
Anna, before I launch into my anxieties about this decision, your thoughts on it?
I mean, Ben, I think that you and I probably agree that the holding, the part of the opinion that requires a holding that the statute does not apply to former federal officials, I think just cannot be right and is not right. I think it frustrates the purpose of the statute. I would not, if I were on the 11th Circuit, which I'm very much am not and will never be, I would not, join in that opinion in terms of as far as that part of the opinion goes. But I certainly think that the alternative grounds that they laid out, I mean, Ben, I think that we, as you said, we have said before that Mark Meadows had the strongest case out of any of the Fulton County defendants for removal. But I ultimately think that they came down on the right side of whether or not he should be able to remove, probably, in my view. But I am really interested to see if he decides to appeal. It's, as far as I'm aware, as of, right before recording this, there has been no notice of appeal yet. I wonder if Meadows is considering, what it would mean if he did appeal to the Supreme Court, if they did grant cert and actually decide the case on the merits. And then ultimately make a decision on that second part, which is whether he was acting within the scope of his official duties. That could affect his defense, but substantive defenses that he intends to raise later on down the line, whether or not it's in federal court or before Judge McAfee in state court. So I think that he has a decision to make here about the risks of potentially trying to appeal. And so we'll see. But I really don't think that the part of the judgment that is about former federal officers being able to remove, I just don't think that's right. But what do you think, Ben?
Well, so let's start with what I think is the easy part. The part about not applying to former officials is just not right. It's crazy, because it's kind of textualism run amok. It's a bunch of, pardon me, I mean, Judge Pryor is a smart guy, but he looked at this and said, wow, the statute's in the present tense. He's not an official, therefore it can't apply. And if you take that logic seriously, then the state of Texas can indict Joe Biden the day that he leaves office for facilitating abortions, under their nutty law. And Joe Biden, former president of the United States, cannot remove that to federal court on grounds that, he was acting in his commander-in-chief authority and, providing health care to U.S. service personnel. that's the import of that opinion. It simply cannot be right. Now it may be that it's that it's a kind of, read the law strictly though the heavens may fall kind of thing. But I think we shouldn't, give aid and comfort to it as a reasonable ruling because it produces an attractive result in this context. It's a very, the idea that any state prosecutor can haul a senior federal official into local court the moment they leave office, and they can't get a reasonable forum for. Now, Fani Willis is not a crazy person, and she's not, in my opinion, pursuing a vendetta. But there are local officials who do pursue vendettas against federal officials, and I think the whole purpose of this statute is to prevent that. And I do think vindicating the purpose of the statute is valuable here. And I'm frankly a little bit appalled that the panel kind of agrees on a theory that, maybe gets the right answer vis-a-vis Mark Meadows, but as Shannon points out in the chat, really empowers like the people like Ken Paxton in Texas. And I think it's very dangerous and we should be wise to it. On the other question, which is assuming that they're wrong on that, does Mark Meadows get removal or not? As we have discussed, I think it's actually a pretty hard question. It's if Mark Meadows were a junior secretary and had been like all he was doing was kind of setting up appointments for the president, I would say, yeah, of course he gets immunity. An arm of the president and nothing more. And the fact that those were personal appointments or in his capacity as a candidate, I wouldn't hold a secretary to that. Now, constitutionally, it's pretty hard to argue that Mark Meadows is differently situated from, say, Rosemary Woods. But we all kind of feel like he is because he's a grown-up and he's a former member of Congress and he's a big shot in his own right. And so I don't know what the right answer to this question is, but I'm sure that this theory is not it. And I do worry about the danger too, among other things, Biden administration officials. The message, it seems to me, that the 11th Circuit has sent is don't resign. If you fear state officials, stay in office. I don't know. Am I overdoing it, Anthony?
No, I don't think so. So I think that I think one thing is I will say that when Fani Willis or when this so let me back up. So there was a decision on a case called Pate that came down back in October. That had a kind of similar flavor of question about prosecutions related to the service of former federal officials. Basically, this guy was harassing former federal officials by filing these false liens, and there was a question of whether, on account of their service, which is the term of the statute, meant former federal officials, or it only meant current ones. And the court, what I think in a very similar, very stringent, overly stringent form of textualism, said, well, no, former officials don't count. Like, it has to be a current situation. And I said that, Fani Willis might be very well tempted to lean into that argument because, it's an easy winner. But I think, strangling text in this kind of overdone textualism that doesn't really serve the purpose of the statute is a bad form of judging and a bad form of lawmaking. And I think so too here. I think it's a bad decision. But I also think, right, that ultimately too, I'm not sure. I mean, it depends on, I mean, maybe I'm wrong, but I'm not entirely certain how much the venue would weigh on a state prosecutor, right? Because it's not, of course, it's not immunity from a prosecution. It's just providing a more neutral venue for the prosecution and a more
And
streamlined.
let me just explain that for people who don't have an intuitive understanding of that. This is not about whether Mark Meadows gets tried for the crimes alleged in the indictment. This is about whether he gets tried in Fulton County Court or whether he gets tried in federal court for the same offenses under state law. And there's a very good piece by one Anab Bower on Lawfare about what actually turns on this question that I refer you to if you have any interest in diving deep.
We wrote that piece together and with Alan Rosenstein as well. So it wasn't just
Yeah, but the
me.
relevant portion is by you.
But yeah, I mean, but that's the thing, right? It still comes down to prosecutorial discretion. I mean, of course, I don't trust every prosecutor across the country to not be partisanly motivated and right, try to indict, former officials of any administration just because of policy disagreements. So, I do think the statute is wrong or has been wrongly interpreted. I do think it should apply to former officials. But I'm not certain that all is, the sky is going to fall as a consequence of the change or, limiting the venue options. Although I think Congress should make it very clear that the statute applies to former officials, because I think it is important that if they are acting in their official duties, they should be able to remove even if they've left office, because of course you don't want to dissuade people from going into federal office or serving the public if they think they're going to be liable to suits in very unfavorable venues. I think that can't be right. But I think the other thing too is, with Mark Meadows, I was initially kind of hem and hawed on whether or not he was entitled to removal, because I thought, well, a lot of the things he was doing were in fact things that make sense, checking in on meetings, keeping the president on time, even though there were other things that he did that certainly were not related to his job. And I think it's a real question, in some of the bigger stuff, right, was, whether Mark Meadows was acting under the color of law, right, when he came down to Fulton County or to Cobb County rather, to check in on signature matching. Was he acting under color of law when he was connecting, Donald Trump with Brad Raffensperger? I'm not really sure he was, but he certainly was doing things within the scope of his work there. So, I mean, I think it was a really close question. But right, the real interesting thing here about the RICO charge is like, right, none of these underlying acts have to be necessarily, everyone proven, right? Because the real problem for Mark Meadows is that he was in part of a conspiracy. And so, I think it's really complicated in part because Mark Meadows was doing things that seem to be on the outer limits, if not outside his scope of his duties as chief of staff, but fundamentally he's being charged with a conspiracy that clearly would never be within the scope of his duties. So I think it's just really complex, and it's messy, again, in large part of just by virtue of not only what's being alleged in terms of these kind of important data points of conduct, but fundamentally he's being charged with this conspiracy-based charge, which I think kind of just makes it a lot messier of a situation than it would be for many other cases.
So a reminder to everybody that unlike some other defendants in this case, Mark Meadows is represented by a highly professional counsel, George Terwilliger, who's a former deputy attorney general. Bob Bittman, I believe, is on that team. It's a very strong team at McGuire Woods, and actually their briefs are a pleasure to read and don't have any of the zaniness of some of the other stuff that you get in some of the Fulton County cases. I'm curious what you guys think their next move is. One thing, I don't see why there's a reason why they shouldn't ask for cert, right?
No, I don't think so. I mean, I would if I were them. What's the loss? The thing is, right, it's not as if so I think it's important for everybody to remember too, right, that as this litigation is continuing on in the federal courts, so too is the movement in state court, right? So the federal removal statute, as the kind of threshold question is litigated about whether or not Mark Meadows his case can be removed, the proceedings in state trial or the state trial court are going on. So I don't see any big any big difference in terms of what's going on in state court. So you might as well give it a shot, full well knowing that you're going to have to continue to litigate in state court anyway. So it's not as if he has a really big decision about whether to kind of take something off pause in Fulton County Court and change strategies. I think you might as well try it and then just kind of focus on the nuts and bolts of the motions practice in state court.
I think that's right. What do you think, Anna?
I mean, I don't know. I think on one hand that's right, but on the other hand, it's like I kind of alluded to this before, but it's already bad enough that you've got Bill Pryor, a widely respected conservative judge, saying that Meadows was not acting within the scope of his office. If Meadows expects to raise a supremacy clause immunity substantive defense down the road, which is kind of a part of the inquiry here, but a little bit of a different kind of standard. But if he intends to raise that and hang his hat on having a supremacy clause immunity defense, whether it is because he can raise that in state court before Judge McAfee if the case stays there, he can raise it in federal court if the case is removed. But I mean, I don't know that you would necessarily want the Supreme Court if you're concerned that the Supreme Court might grant cert and then might end up deciding the question of whether Meadows was acting within the scope of his office. I think that there is in the back of your mind a concern about that prejudices your arguments before Judge McAfee or whoever about your substantive defense or even potential jurors who are following the case. I don't know that that's necessarily something that would stop Meadows, and I think maybe on balance if Meadows has more of a kind of delay factor in terms of wanting to delay the proceedings and isn't someone like, for example, John Eastman, who wants to go ahead and get to trial, then certainly going to the Supreme Court would be your logical next step because you're trying to draw things out. So I don't know. Do you think that that's something or nothing or what? Tell me if I'm wrong or if I'm right, Ben.
Oh, I think you're right. I mean, I think this is a case that is unbelievably more complicated than the federal case because these different defendants actually have different interests. And, it's clear to me that Trump made the judgment, or rather Steve Sadow, Trump's crocodile boot wearing lawyer in Fulton County, made the judgment that he actually likes his chances in front of Judge McAfee better than he likes his chances in front of the judge, the federal court judge whom he might get instead. Meadows has clearly made a different judgment. Why that is not obvious to me. Maybe the judgment is Scott McAfee seems like a very fair young man, and we don't know who we would get in federal court. But the point is, people are making very different judgments about where they want to be, and they're making different judgments about all kinds of things, how fast they want the trial to move, that makes this case just wildly different from the federal January 6th case where you have one defendant and one prosecutor, and you have a very linear confrontation between the interests of the federal government and the interests of the defendant. And similarly, the same thing in South Florida, although you have this wackadoodle judge who's a kind of actor of her own. But you know, you've got a real in Fulton County, you've got a real multiplicity of actors, and none of them files in their briefs their motives. You know, I'm doing this to try to you know, force to put a little bit of pressure on the prosecutor to cut a better deal with me based on the back channel discussions we're having about a plea. Nobody writes that in the brief. So you have to kind of figure it out, and it's completely non-obvious. And I think so yeah, I agree with you. I think the technical term is an opaque mess. What do you think, Anthony?
No, I think that's right. I mean, I think Anna's spot on too, right? There's a PR dynamic to this as much as there is just a kind of ordinary, you know, criminal law defense strategy here. You know, being handed a loss by the Supreme Court would be pretty devastating. You know, on the other hand, you know, I guess you know, if I'm trying to game this out, you know, am I more like if they grant cert, am I more likely to win than not? I mean, I think maybe my thinking would be there's a really good chance, or at least a decent chance, that I will win somehow if they grant cert. And so maybe the real loss that I'm facing is a denial of cert, in which case I can kind of escape the bad PR. But if I get the Supreme Court to grant cert and then I lose on the merits, then I have a massive PR problem, in addition to you know, a potential legal problem, in the sense of, just like Anna said, right, where there's now ink spilled by the justices that is you know, kind of disfavoring their you know, that disfavors the you know, Mark Meadows, some of his defenses that'll have to lodge in state court. But you know, who knows? Like you said, who knows what's going on in their head? If it's the jury pool that they want, or if they're just trying to delay things, or if they really wanted a federal judge to hear some of their federal immunity defenses. I mean, it's really hard to say. I have a hard time figuring out you know, what Mark Meadows really wants out of this, except for the fact that I assume he thought a federal court in Georgia, or the 11th Circuit, would be much more favorable to some of his immunity claims down the road. But it seems like now, right, that even the 11th Circuit wouldn't be a particularly favorable circuit for those claims either.
All right. So let's move on to another case that appears to be headed toward the Supreme Court, which is the Colorado Supreme Court's decision on Section 3 of the 14th Amendment. We're going to go a little easy on this one today because we had an entire hour-long discussion of it yesterday, which I incorporate here by reference and refer you all to. But I would be, but we've got a different group of people here, so we may as well chat about it a little. Anna, give us a sense of where we are with that for those who missed yesterday and for whom Section 3 of the 14th Amendment sounds like, I don't know, Greek.
Right. So this is a case that is a Colorado case. It involves Section 3 of the 14th Amendment, and the question is whether under that section of the Constitution is Donald Trump qualified for an office of the United States as someone who has been potentially alleged to have, you know, participated in an insurrection related to the events of January 6th. The trial court judge in Colorado ultimately decided that Donald Trump did incite insurrection or participate in insurrection, but that basically that the office of the presidency is not an officer of the United States, and so therefore the section of the Constitution did not apply. It then now has just recently gone to to the Colorado Supreme Court. And in a 4-3 decision, the judges on that court ultimately determined that yes, the Section 3 of the 14th Amendment does disqualify Trump from the office of the presidency, and that he should then, be disqualified from being on the state's ballots in the primary and the general election. However, that decision is stayed pending Supreme Court review if should Trump decide to ask for Supreme Court of the United States to review the decision. That stay is, as I understand it, and Ben and Anthony, correct me if I'm wrong, the decision is stayed until January 4th, and it is then stayed thereafter as so long as Trump files a petition to the Supreme Court of the United States by January 4th. Is that correct?
Yep.
Right. And of course, what's really interesting about this decision as well is that although it was a 4-3 decision, the judges who dissented did not, disagree that Trump was someone who participated or incited insurrection. They, had some different kind of opinions on whether or not Section 3 of the 14th Amendment is self-executing. They had some different opinions on the kind of minutia of Colorado state law. But it was very interesting that, a majority of this court, state Supreme Court, had decided basically that Donald Trump was an insurrectionist, at least as far as that term applies under Section 3 of the 14th Amendment. So I think that's a good summary, but the two of you, please jump in if I missed anything there that is relevant.
Anthony, do you have anything to add?
No, I think that covers the issue. Although, so the one thing I do think that's interesting is I have had this brief inclination of maybe Donald Trump won't actually appeal this decision because the likelihood of Donald Trump winning Colorado in the general election in particular is nil. And, now to strike him from the primary ballot, he can play the victim card, and he can also force the other contenders in the Republican primary to make a decision about whether they will contest the primary in Colorado. And so it not only can he play into the victimhood, the victimhood narrative that he likes to play, but he can use it to pit himself or to pit his the other Republican contenders in the primary race to kind of fight this out with him or against him. And I think that could be probably very valuable. I think we would be in a very different scenario, right? If someone in Georgia litigated this in the Georgia Supreme Court, right, said no, Donald Trump is ineligible to be listed on the Georgia ballot. So, that I think there might be some political incentive to let this rest, and then just from his perspective, hope no truly competitive state would or even more states for that matter would go down that route. So I think
isn't that?
Yeah.
So it seems to me that has certain dangers because, like, the Minnesota Supreme Court kicked it down the road, but it didn't rule on the merits of it. And if you let this go back to the Minnesota Supreme Court with with the Colorado court as precedent, admittedly not a binding precedent, but not a repudiated one either, maybe you end up in a crisis in the spring when Trump is clearly the nominee, and all of a sudden the Minnesota Supreme Court says, gosh, I guess the issue's ripe now, and boy, our sister court in Colorado says, he's disqualified, and we follow that, and then you have a much tighter time frame for adjudication. And by the way, the consequences if you lose are really dire.
Well, I mean, here's the thing. You and I care about, and Anna, we care about, stability and in the law and stability in our political order. And right, those are things that most people value. Donald Trump thrives in chaos. So I'm not really certain that, the timing would matter to him, because I think ultimately from his perspective, right, if you're likely to win at the Supreme Court, then you roll the dice and see what the Minnesota Supreme Court does, and then you force the United States Supreme Court's hand, in the middle of the summer, and maybe eke out a legal victory in, we'll say, June, right, in kind of an emergency scenario, that might be a otherwise very grim few months of legal news for Donald Trump because of the various proceedings that'll be going on, right? So there might be some, virtue from his perspective of getting a clear victory from the Supreme Court, perhaps reversing a Minnesota Supreme Court out of that chaos than doing it from the Colorado Supreme Court. I don't know, but I don't think anything Donald Trump generally does, or the legal teams by and large, with I think the exception of Georgia in particular down here, his legal team doesn't always do the thing that I think is the most reasonable, logical, and thoughtful. And so, it's anyone's guess what he does. But I'm not necessarily sure, again, that it's in his interest to have this case be the one to appeal and to have it settled sooner rather than later. I'm not sure that's to his immediate benefit.
Do either of you know if there has been a litigation on Trump's ballot access in any of the battleground states? I know there's, pro se defendants who've been filing things all over the country, but I mean a serious effort. And, I assume they picked Colorado because the state law, and Minnesota because the state law claims were favorable. But eventually this thing only matters if it stands to get Trump struck in states that he could actually win. Do we have any sense of whether there's been any serious effort in those states?
I don't have a sense, but I will check the Lawfare Section 3 litigation tracker, which might give me a better sense of whether there is, which is, Ben, maybe this is a good time to let everyone know where they can find that litigation
Yes,
tracker.
there is a Lawfare Section 3 litigation tracker, which has been discovered by the mainstream media, by the way, and has recently been discussed by Jill Lepore on the Political Scene, the New Yorker podcast, and it's been featured in New York Times articles. So everybody's talking about the litigation tracker, which I will share it has been shared in the YouTube. So yeah, I mean, I think the really interesting question, if Anthony is right, is that, maybe it's not in Trump's interest to appeal from Colorado. What are the next states that are that, the crew folks or the free speech for the people folks are likely to target that would force an appeal? All right. We are getting ready to go to the Q&A, to audience questions. So again, once I do, I'm going to close the questions so that we don't have an endlessly growing list of questions while I go through them. So this is your last chance to add questions to the queue. Anna Hickey, if you could bring in people in order in which they appear on the queue. We're going to start with Josh, who wants me to read his question. Will the DC Circuit panel holding that Trump is not immune from civil suit for his actions on January 6th have any bearing on the Supreme Court's deliberation if they decide not to wait for the DC Circuit on the question of his immunity from criminal prosecution? So I will give an initial thought on this, and then if either of the two of you have additional thoughts, please jump in. So first of all, as a formal matter, the DC Circuit can never bind the Supreme Court. It can merely influence the Supreme Court by the force of its reasoning. In this case, there is some reason to expect that that might happen, and that is that that at least two of the judges who are on this opinion, Chief Judge Srinivasan and Greg Katsas, are among the most respected judges of their political persuasions around, and the fact that they and Judge Brown are kind of all on the same page about this, I think does carry a certain moral weight. The bigger issue, in my view, is that the difference between a criminal case and a civil case is enormous. And the threshold issue for the Supreme Court is going to be, does anything in the civil realm affect our judgment of what immunity looks like, if it exists at all, in the criminal realm? And I suspect those are a kind of neither fish nor fowl. You gotta, you can have very, very broad immunity in the civil realm and none in the criminal realm. And I think that's a deeper concern going to be than the Supreme Court's respect for this panel decision. But look, if any panel decision is going to influence the way the Supreme Court did, the fact that the DC Circuit took a year and basically came to a unanimous, very cross-ideological view of this is, that potentially carries some weight. I'm curious if either of you disagree with that. I see heads shaking. Nathan writes, a question for Anna. Is it fair to assume you're working on a potential podcast interview with Fulton County DA Fani Willis? And what are some of the questions you would ask her? We're hitting a sore spot here, but Anna, express this is, airing of grievances here.
Nathan, we are working on it. We have worked on it. We are trying to convince Fani Willis to come on our podcast. So Jeff DeSantis, if you are listening to this, email me back. No, we would absolutely love to have the district attorney on our podcast. It hasn't been something that has worked out so far, but we're hopeful that in the future she will join us at some point. She has recently done some interviews with the AJC and I believe the AP last week as well. So Fani Willis, it's Lawfare's time to shine. Come and join us on our podcast. In terms of what questions I would ask, I think it would really just depend on what's going on in the case at the moment. And I think that probably a lot of the questions I would also ask as well would be things that I might get not much of an answer on. But, I would love to know, for example, what went into some of the decisions around, people who were recommended for indictment, but then the district attorney declined to prosecute. There's 19 there were 19 co-defendants in Fulton County, but there were a lot more people who are unindicted co-conspirators. That's definitely not a question that I would ever get an answer to on the record. But I think I would be really interested in knowing what other questions would I ask Fani Willis. I think right now, one thing that's on my mind is what's going on with the Trevion Cootie situation. Is it, what is happening? Is there going to be a motion to revoke bond? Could there be potential forthcoming new charges? So those are just a few things off the top of my head. Anthony, are there any questions that you would ask Fani Willis at this time, as someone who's been following this case very closely?
Well, first of all, today she was hanging out with Shaq, so I kind of want to know. She had some great shoes and a gingerbread sweatshirt that said, what did it say? It said, "Oh snap!" And I'm like, I just want to hang out with her. So maybe I don't have deep, thoughtful questions as much as I just want to hang out with her and Shaq. But if I were to ask a question, I mean, I think, I don't know. I mean, I think the biggest thing I would be curious about is, what's her actual plan, in terms of Jeff Clark and Mark Meadows. And I know that's the one she will never answer, but that's what I really want to know, because right now, and any big conspiracy RICO case, we all know, like, there's the big fish that they really want to get, and then there's the other folks that they're more interested in turning into state's evidence. And so, I think Rudy Giuliani and Donald Trump are certainly, right, the big fish that they want to have at trial ultimately. But then, I'm less certain about Mark Meadows, John Eastman, and Jeff Clark. Like, where do they fit in that kind of that scheme, or that that scale of big fish to middlemen that they just want to have evidence from? So that would be my big question.
All right, Ruth, the floor is yours.
Well, this is probably a simple question. If the Colorado case is appealed to the Supreme Court, and I've heard people discuss that possibly the court could say something like the eligibility regarding insurrection should be determined by the voters, would that have an impact on determination of eligibility for other factors such as age or place of birth?
Anthony, do you want to take this one?
Yeah, so I think that's where the issue really needs to get decided, probably from the Supreme Court's perspective, on this matter of whether the presidency, right, is an office of the United States that's covered by Section 3 of the 14th Amendment. In that way, I think they can preserve the ability to challenge, right, those other requirements, which are very plain, right? You're either 35 or you're not. You were either born in in the United States and subject to the jurisdiction thereof, or you weren't. And so they can avoid that kind of slippery slope, and then just say, well, the presidency doesn't get covered under the 14th Amendment by its plain text, and they're done. So I suspect if the court does take this and resolves it, that they'll be able to resolve it in that, or they'll try to resolve it in that way, so that they don't create those other kinds of questions down the road, and they still kind of limit a ruling favorable to Trump in a way that they can say is not pro-Trump or not anti-Trump, but just faithful to the constitutional text.
All right. Jared asks the critical Eileen Cannon nightmare scenario question. In the classified documents case, if it happens, if the jury returns a guilty verdict, could Judge Cannon render a judgment notwithstanding the verdict, overturning the jury conviction and entering a judgment of not guilty? If she does that, is it appealable by the prosecution without violating the Fifth Amendment? Would that lead to restoring the jury's verdict or a new trial? I think the answer to this question is really simple. Yes, she can issue a directed verdict. No, it is not appealable. A verdict of acquittal is never appealable. And the only thing that gets in the way of her ability to do that is judicial conscience, to whatever extent that has a claim. Am I wrong about that?
These are moments where I'm glad I don't teach crim law, because I can just say, I have no idea.
I believe that this is a classic double jeopardy question, and there is nothing that prevents that except the ridicule of public opinion. But if somebody who knows more crim pro than I do thinks otherwise, I would be interested to know.
Yeah, this is where I wish that I took crim pro adjudication, not just crim pro investigations. But so my only question been on what you just said, is because I think the question was, if the jury returns a verdict, can she then enter a directed verdict notwithstanding that? You move for a directed verdict before the jury renders its own verdict. So I mean, I just procedurally, I'm not really sure if you can, if if it would work where, you know, a jury actually returns a verdict and then Judge Cannon says, "Oh, sorry, I'm gonna," you know,
Right.
so
But I think, again, I'm talking out of my ass here, but I think the answer is a judgment notwithstanding the verdict is a judgment of acquittal. And once you have been acquitted, first of all, an acquittal is not appealable. An acquittal on the evidence is not appealable. And secondly, once you've been acquitted, you can't be tried again. That's the essence of double jeopardy. And
yeah, I
so
think that's right.
I think the answer is if Judge Cannon wants to flagrantly violate her oath, there's nothing that actually prevents her from doing that. The problem with it, and the reason that we don't spend all of our time fretting about this possibility, is that you would actually have to justify that. You'd have to like kind of write an opinion that says the prosecution presented X evidence and Y evidence and Z evidence, and I find that no reasonable jury could find that this satisfies the elements of the offense. And presumably the nature of the case the government is going to present is going to make an opinion like that extremely difficult to write. But look, you know, there are a lot of Southern white people who didn't go to prison because jurors or judges did things like that. So it's, not, I mean, during the civil rights era. So it's not like, I don't want to pretend it's, that kind of, it's not jury nullification, it's judicial nullification, granting motions that are completely unmerited, but that aren't appealable, is okay. So now John Hawkinson is telling me that Federal Rule of Criminal Procedure 29D3 says that an appellate court can reverse the judgment of acquittal, and the trial court must proceed with the new trial unless the appellate court orders otherwise. So maybe I'm full of shit on this. How about this? I'm going to look into it and figure it out for next week, and I will report back.
We won't be here next week, but we will figure it out.
Well,
after
maybe the
new
week
year.
after. Maybe
Yeah.
we won't be here next week. All right. Jeff asks, will the very real possibility Trump may be convicted in the January 6th case affect how the Supreme Court decides the 14th Amendment disqualification issue? I don't know the answer to that. Do either of you? You got us stumped on that one. I mean, remember there are 9 justices. They can be affected by very different things. And, which of them look forward to things that might happen is a tricky business. None of them will admit that, but it's not crazy. All right, Josh asks, if Meadows wants delay, wouldn't asking for en banc review before asking for cert provide more delay? Anthony?
No. And here's the quick answer why. So right, the part of the decision from the 11th Circuit rested on that decision that I talked about called Pate, which had to deal with a different statute with a former federal official. That decision was heard by the 11th Circuit en banc. So, I think as Judge Pryor would go, as Judge Pryor went in this case, as the majority of the 11th Circuit went in that Pate decision, so too they would go here. And so I think, right, again, ultimately the most important point to reiterate here is that the proceedings in the state court are still going on no matter what's happening in federal court. So the question of delay It's kind of, it's really a question of not so much delaying anything that's happening in state court, but delaying how long he still has to litigate in federal court, which is only to his disadvantage and to nobody else's. So I don't think that en banc review is likely to be asked for, and I don't think would help him whatsoever. I think would only just hand him another defeat.
All right, last question. This one has an easy answer, fortunately, unlike those directed verdict questions. If the Colorado ruling stands and isn't appealed or isn't heard by the SCOTUS, and if Trump wins the election, what happens? Is he not the president of Colorado? All right. So the answer to that question is simple. You don't, sometimes people have been elected without even appearing on the ballots in certain states. The Electoral College is a national institution, and it elects the president of the country, not the president of any individual state. And so, I don't think John Breckinridge appeared on the ballot in every country, in every state in the country in 1860. He was a regional candidate. He got regional support. But Abraham Lincoln was the president. I don't think Abraham Lincoln probably appeared on the ballot in South Carolina either, but he was the president of the country anyway. Anybody have any? So in other words, if Trump wins, he gets to be president of Colorado, even if he's in prison and Colorado didn't have him on the ballot.
Although I think what you would see is the first executive order that he issues would be challenged, and whoever had an adverse, interest there would just say this executive order is not valid because Donald Trump is not validly president of the United States. So I think the litigation would pop up again. I don't think it'd be successful at that point, right? But I think you'd see people still pushing that question, even though he would in fact be president of everybody or over everybody.
Anna, you get the last word today.
Well, I mean, I think I agree with Anthony, but I actually have a different question that I want to ask before we leave. That's a question for the panelists. Can I do
All
that?
right.
Okay. So we talked earlier about Mark Meadows and the opinion by the 11th Circuit. Something that we didn't talk much about, but Anthony just referenced, was Judge Rosenbaum's concurring opinion, which was quite interesting because although she agreed with Judge Pryor in his, kind of majority opinion or the opinion for the court, she wrote separately to express her concern about the idea that former federal officers could not remove under 28 USC 1442, the removal statute. And it was a very interesting concurrence because she kind of said, oh, I have this nightmare scenario in my head in which someone leaves office. And Ben, as you kind of referenced, it would be a situation where as soon as someone leaves office, they're indicted by, a very aggressive state prosecutor who wants to, prosecute the enforcement of unpopular federal law. And so she kind of implores Congress in this opinion to change the law. What do you two think the appetite for that kind of legislative reform would be within, the current Congress that we have? And if there was some kind of reform, I mean, I think the answer to this is maybe no, because typically laws are prospective rather than, retroactive and that kind of thing. And it would depend on how the law is drafted. But could we have a situation in which any change to this law would affect what's going on, with these removal cases and the criminal cases, and, whether someone like Mark Meadows might have an argument that, oh, well, now I can remove, that kind of thing. So yeah, sorry, that was a long-winded question.
Well,
Go for it, Anthony.
I think the answer is probably no appetite to touch it right now because it's probably too charged. And certainly, I think anything that would be put in there would have an express exclusion for Mark Meadows in order for Democrats to support it. But the one quick thing I'll say is I'm very sympathetic to that concurring opinion and what Judge Rosenbaum and Judge Abudu signed on to. in terms of asking Congress or, encouraging Congress to fix it. But I do think that the removal statute needs like wholesale reform. Like tweaking it just to bring in former federal officials is probably not the answer, because I think it's just kind of very cumbersome and doesn't make a lot of sense as some of the doctrine that has been applied by essentially requiring people to put their case on before they get removed. And I think that it's going to require a lot of thoughtful deliberation in order to get it right and to fix it. But I don't think we'll see any fixes anytime soon.
I said that Anna gets the last word, but I actually lied, because Jared gets the last word because he has a follow-up on his earlier question. Jared, the floor is yours. But you got to unmute yourself.
Jared accidentally raised his hand. He said in the chat.
This is one of those butt hand raise situations. We're going to adjourn. Thank you all for joining us. Thanks to Anthony, our special guest. Come back and join us again. And thanks to you all. And to Anab Bower from the encyclopedia room of her palatial mansion. And we will see you. We will be off next week, but we will see you the following week.